Hello and good morning. This is our 9:30 a.m. February 1st joint committee briefing between the Hawaii State Senate Committees on Commerce and Consumer Protection, Health and Human Services, and Agriculture and Environment. We're in room 229, and we are here to hear from the Department of Health, Office of Medical Cannabis Control and Regulation, the Department of the Attorney General, and we also have leadership here from the National Cannabis Regulators Association to discuss the implementation of Act 263 from 2023 last year, including the status of administrative rulemaking and other updates around hemp cultivation, manufacturing, and retail. So thank you again to my fellow co-chairs for allowing us to convene this briefing. And we will begin, I believe, with the Department of Health. Good morning.
Good morning, chairs and vice chairs, members of the committees. My name is Michelle Nakata. I am the program manager for the Office of Medical Cannabis Control and Regulation, representing the Department of Health Director, Dr. Kenneth Fink. Let's see. The share screen option is not showing for me. Okay, sorry, it is now. I got it. Okay, there we go. Okay, as Senator had said, I am here to report on the status of the Department of Health's implementation of Act 263, Session Laws of 2023, which was House Bill 1359. And as I mentioned, I represent the Hawaii Department of Health Office of Medical Cannabis Control and Regulation. So Act 263 did have a lot of different aspects to it. I mean, for Department of Agriculture as well as Department of Health. So I am here only speaking with regards to Department of Health's implementation. And these amendments are primarily those to protect public health, and then also to allow the hemp producers to be able to sell hemp biomass, which was something that they wanted, and also to report on the status of the toxicologists, which we were provided funding for. So this is a timeline of the actions that we've taken to date. The Act 263 became effective on July 1st. By September 8th, we had stood up a permit system because the Act transitioned hemp the hemp process, the hemp registration process from a registry to a permitting process. By January 8th, we had completed draft revisions to the administrative rules to allow for the changes in Act 263. And then by January 17th, we had completed an RFP draft for the toxicologist position. And those are currently under review by our Deputy Attorney General. So with regards to the hemp processor permit application, the application is available on the Department of Health Office of Medical Cannabis website. And basically all that happens is applicant completes the form, they can return it by email or mail to our office, and then they must make payment of $500, which is the permitting fee, by check to us. I should note that we are actually in the process of procuring an electronic licensing system. This is both for our medical cannabis dispensaries, but it's also going to allow the hemp permits to be done online as well as make payments online. So I think it's going to really help make that process a lot more efficient. The changes to Act 63 that we are trying to make to our administrative rules are those to conform language, the applicability, definitions, et cetera, provide criteria for processing hemp biomass into crude extract, define testing criteria, basic testing criteria, and that's really only mycotoxin and total THC, and then to ensure that the crude extract is under 0.3% THC. We also have crude extract labeling requirements specifying that it's not yet fit for human consumption at that point, and then also to allow for sale to other permitted processors. And this actually is a benefit to the industry because it opens the door to out-of-state sales. And then also to apply total THC limits to manufactured hemp products, as well as labeling requirements for retail sales in Hawaii. When we were trying to work on the administrative rules, we realized that there were a couple of issues with Act 263 that prevents us to make changes that we would like to make. One of them was that Act 263 adopted a very restrictive definition of manufactured hemp product, and that would prevent the Department of Health from allowing the addition of new product forms. An example of this would be CBD gummies. So what we did was we proactively submitted a legislative proposal to amend the definition. This was included in the governor's package, and it has been introduced as House Bill 2449 and Senate Bill 3138. In addition, we learned that we can't issue hemp processor permits to individuals or applicants that are not already licensed by the USDA to grow hemp. And the reason for that is there wasn't a matching change to give the Department of Health statutory authority to conduct the criminal background check. So we have to rely right now only on those individuals who are already USDA licensed. So also to correct that, we submitted a legislative proposal to enable us to do the background checks. This was also included in the governor's package and introduced as House Bill 2444 and Senate Bill 3133. With regards to the toxicologists, legislature appropriated $50,000 in general funds for us for this year. We are in the process, as I mentioned, of soliciting for that. We have a draft RFP completed. Some of the challenges that we've experienced with regards to enforcing hemp products are that although Act 14 back in 2020 established the hemp processor program under the Department of Health, and it also established the hemp processing special fund, the regulatory oversight was placed on the Department of Health Food and Drug Branch, but it was really an unfunded mandate. So there were no position counts, there was no operational costs. The special fund was supposed to allow for that, but as of today, the total balance in the special fund is $5,500. So it's really not enough to fund positions or provide for operational costs. The result, and then what happened at the same time is there began to be significant concerns about hemp products. In September 2021, the CDC, Centers for Disease Control, issued a health alert regarding reported cases of Delta-8 related adverse events. Now, Delta-8 is a compound that's found in cannabis plants, including hemp, but it is found in very, very trace amounts. So the Delta-8 that is present in products, all of the Delta-8 that is present in products except for the trace amounts is synthesized. It's chemically synthesized, and it is intoxicating. And so CDC issued this alert, and then in June 2022, FDA also issued a warning that a lot of these Delta-8 products were being packaged in concerning packaging that was was easily confused with commercially available non-infused products. And then we saw this happen here in Hawaii. In June 2022, the Department of Health received a number of complaints of individuals becoming ill after consuming edible products that they had purchased or been given as samples by a retail location called Pinky's Empire. They had 2 stores, one in Waikiki and one in downtown. So the Department of Health did go out. You can see that we embargoed a number of products. And, you know, it's a little hard to see on the slide, but all of these products do say that they are hemp. They're derived from hemp. And so, you know, this is the concern that we have. It was very highly publicized. The THC, Hawaii News Now actually did an investigative report where they went out and they purchased products from these retail locations, had them tested by a certified testing laboratory, and the levels of actual THC in the products were extremely high, higher than we allow even in our medical cannabis dispensaries. So the owner of the store did, file a lawsuit against the department for the action that we took, but we did prevail in federal court, which confirms, for us that the Department of Health does have the authority to regulate these products for consumer safety, and protection of the public health. And so we do have some samples here that we would like you to take a look at. We'll bring them up and pass them down. The first product I should emphasize is a compliant product. This is the type of product that would be fully acceptable to be sold. It's packaged properly, does not contain any intoxicants, very, very properly labeled. The items that are in the white package are things that are unacceptable. And I think if you take a look at those, you can easily find a reason why we don't find them acceptable. For some background, if you're wondering why I'm with the Office of Medical Cannabis Control and Regulation and it's not the Food and Drug Branch that's speaking, in 2023, the hemp product oversight was transitioned to the medical cannabis program. And the reason for that was primarily that the Food and Drug Branch did not have actually any personnel resources. So they needed somebody to maintain oversight. And then, because of that, we requested funding for positions, and Act 164 did provide us with 4 full-time positions. However, they are not, they're not going to be funded until FY25. And the issue continues. The photos that I have in my slide, upper right-hand corner is a screenshot of a kiosk in Ala Moana Center called Grass CBD. They have been found or observed to be selling high THC, intoxicating products. And these are just some examples of products that we've received complaints about at our office.
You said these were all legal, we can taste these?
I would not, they're.
Oh, I got mixed up, I'm sorry.
Not unless you're done for the day.
Thank you.
Okay, and so despite the fact that we do not have additional resources specifically for hemp, our medical cannabis program dispensary section does have 5 surveyors. And what we are going to do is utilize those surveyors, pull them back a little bit from some of the cannabis dispensary inspections that they do, and have them start doing some enforcement around hemp products. Basically identifying the retailers, doing an educational campaign, because we do want to make sure first that they understand exactly what the rules are. And then follow up with on-site compliance checks. Basically, call them out and say, you know, these are the unacceptable things. Ask them to voluntarily remove them. But then again, follow up, and, you know, if they are still non-compliant, then take appropriate enforcement action. And in addition to that, we have stood up a adverse event investigations process. We have an online reporting system on our website. We are in the process of obtaining access to emergency medical services and poison center reports. And we've partnered with the Disease Outbreak Control Division, which is the program that does epidemiologic investigations of illnesses. And we're working with them. They currently conduct all of the investigations for us. And that's it. I'm available for any questions. Thank you.
Members, are there any questions?
Yeah, I had a question. You had mentioned that the gummies and vaping are not currently allowed under Act 263, is that correct?
They are actually not allowed
And that's why,
currently under current rules. And
they're added to HB 2449 and SB 3138 for this session, is that correct?
I am going to have to ask Greg, our hemp specialist, to come up.
Well, you can stay.
Okay.
Morning. Good morning, Greg Edwards. I work for Michelle. So Act 263 gave us authorities to add new products. Previous to Act 263, 328G, the statute already prohibited products like gummies or chocolates. It's a very narrow form list. Act 263 gives us the authority to add new forms. However, as Michelle pointed out, the definition of a manufactured hemp product needs to be changed in order for us to actually move down that road and allow those forms, just because there was a tweak in the definition last year in Act 263. Is that clear?
Okay, all right, thank you. Thanks, Jeff.
Senator Richards.
Yeah,
Maybe stand there.
You should probably
yeah,
say
just
You're the expert.
a lot of the conversation we're here because we have a incongruous agreement on what we're doing coming forward between the hemp industry and the medical cannabis. And if I understood what you were talking about, under 263, that gave you jurisdiction to regulate the THC in these products, is that correct?
We actually already have jurisdiction over the products. That investigation that I mentioned for Pinky's Hempire,
Okay.
that actually preceded Act 263.
So you have that
So
authority.
we already do
So
have
are
that
you
authority.
exercising that authority broadly?
I'm sorry, I don't understand what you mean by
Meaning, are you
broadly.
enforcing it's my understanding the hemp industry is feeling they're caught up in this. And the problem is not so much our local hemp industry, it's the products that are coming in.
Understood.
And so are we enforcing that the products coming in are regulatorily acceptable?
Yes, the enforcement will be against all hemp products, but very clearly that the enforcement is based on separate rules. So hemp rules are Hawaii Administrative Rules 1137, and they are very distinct from the enforcement that we do around cannabis. So the two sets of products, although right now, because we don't have separate resources, they are handled by the same personnel, but subject to two separate rules. The plan is that when we get the 4 new positions that we were authorized for in FY25, we will be standing up a separate unit under the program to manage the oversight of hemp products. We do want to make sure that they are kept distinct.
Again, because the industry is feeling that the enforcement of the products coming in is not being done very well, and they're going to get stuck in this and cause a problem for them. What is your answer to that?
Yes, I will admit, the department has not been doing a good job to date. on enforcement, period.
Okay,
And that's what we want to get started on. You know, we were a little bit disappointed that the positions were not funded until FY '25 because we could have used them now. But the concerns are too great, and we do understand that, you know, the bulk of the egregious problems that we've seen have been the products that are being brought in from out of
Correct.
state. Yes, and we definitely want to address that because that, we understand, is a threat to the local industry.
and to the people.
Yes.
So it's sounding like you want to head in the right direction. How do we get the cannabis, or excuse me, the hemp industry and DOH to have good ongoing conversation? What's the best way to connect? Talk story with you?
Yes, I would say we would love to sit down and talk story.
Okay?
Yes.
I use my legislative pinky promise. Are you going to do that with me?
Yes.
Okay,
yes,
all right.
Yes. I'll have to bring Greg though.
No,
because
that's
like
good.
I said,
No, no, no.
he's-
Well, but,
he's
okay.
the expert.
Okay, so then what I want to do is I want to get you together with the hemp industry to talk story.
Okay,
Okay?
sounds good.
All right. Thanks, Chair.
Any other questions?
yes.
Senator San Buenaventura.
Okay, so I have a number of questions.
Okay.
Okay, I'm looking, we did not get your PowerPoint. We got something else
That's
provided
the
to
Attorney
us.
General's office presentation, which will be coming up next.
I see, so.
So we'll take questions of you now, but we will ask you to stay at the conclusion of the Attorney General's portion as well, so that we can ask
I do
more questions.
apologize.
if
My
we need.
PowerPoint was at very late, like almost midnight last night. I had
Okay.
some IT issues.
Okay, thank you. So, well, my question was, you said that basically hemp farmers now are, the only hemp farmers allowed to grow hemp are those who are federally licensed, right? Was that my understanding? What you said?
The cultivation part, I don't want to speak to because that's Department of Agriculture and I'm not well versed in that. In order for us to register or permit somebody to process hemp into crude extract or into a manufactured product, that part is handled by the health department. And because we cannot do the background checks, so if somebody registers for if they have a USDA license, they've already completed a background check. And so we don't have to do the background check for those individuals. But if there's somebody else who is not a cultivator, who wants to take crude extract and manufacture products from that, we can't permit those individuals right now because we can't do the background check on that.
So upon passage of the bill, would you folks be able to?
If we can get satisfactory language passed to allow the health department to conduct the background checks for the purpose of hemp processors, yes.
Okay, because according to, I guess, the Attorney General's soon-to-be shown PowerPoint, it says hemp cultivation in state is regulated by a state program or the USDA program. So if you folks are going to be able to allow the background checks, you folks will be able to have state licenses for hemp farmers that is different?
It's different because we still only take from after the product is harvested forward. The cultivation will still be under, and Department of Ag does not have a cultivation program, so they defer to USDA.
So is that administratively, it's not by, I guess I'll ask the Attorney General that
Yes, I'm
question
sorry.
then.
I
Okay,
really
because it's
don't
their
know too much
PowerPoint.
about the cultivation side. I'm sorry.
So, okay, let's talk about administratively. You talked about the, what happened, I guess, in Alamoana, where you guys brought down one retailer. What happened to those people that you folks closed down? Do you know?
Do you know what happened to Pinkies? I feel like they're still up and open in Waikiki.
The shop, at least in Waikiki, the shop is under a new name. I don't know what the ownership is, because it's not required that retailers notify the state that they're selling hemp products. So I'm not sure if it's the same ownership. We know it's a different name, selling similar products, at least when we drive by and we see advertisement from the
So
outside.
so should we have this cannabis authority? Do you expect the regulations to include enforcement so that it seems to me those who are compliant are seeing those who are non-compliant being able to get away with profiteering, and nothing is happening to them.
Correct. And as I said, we have not done enforcement, and that's why we want to do it. I mean, it's the same thing that the cannabis industry is seeing, right? They're seeing a lot of unlicensed, illicit activity that's going on that's directly competing with them, and it's really unfair.
So all you folks have done so far is just grabbing the illegal products and not fining or violating or?
We've not done, the only enforcement actions or that we've taken have been associated with illnesses. Because
Department
we haven't had, we just haven't had the resources. So for the most part, we have investigated illness complaints. And where the illness complaints are egregious and we observe that there's selling of a lot of product that's unacceptable, we have taken action. So Pinky's was an example of that.
And the action is basically just taking the products off the shelf and nothing more.
They were embargoed, and then ultimately they were court order seized by Department of Law Enforcement.
So they were just taken off the shelf and nothing
Yeah.
more. Okay, thank you.
All right, thank you very much. We'll have the Attorney General's office proceed with their presentation.
Thank you, Jill. Maybe you want to go next?
Oh, okay. We have online, we have a representative from the Cannabis Regulators Association who will proceed. Good morning and thank you for joining us.
Thank you so much. It's an honor to be able to present to you. I was asked to present on some of the regulatory considerations from a national perspective, as well as trends across other states in terms of how they regulate cannabinoid hemp. And I have a PhD in public health. I don't have any funding sources to disclose, and I don't take funding from the pharmaceutical, alcohol, tobacco, hemp, or cannabis industries. And this presentation is my own. It's not an official position of CANNRA or any of the states that we represent.
If you can briefly, because we can see your name on Zoom, but just for the record, if you can introduce yourself and your organization before you proceed.
Yes, thank you. So my name is Jillian Schauer, and I'm presenting today on behalf of the Cannabis Regulators Association. We are a nonpartisan, nonprofit association of government agencies involved in cannabis and cannabinoid regulation across 44 states, DC, 2 territories, Canada, and the Netherlands. We're not an advocacy group. We don't take a formal position for or against legalization. We're really an education-based group with resources to support government agencies in this space. So we have been focused on cannabinoid hemp for at least a couple years. We are not focused on hemp as an agricultural crop. We are not focused on feed, fiber, grain, or industrial hemp. We are focused on cannabinoid products that are being manufactured for consumption. We are talking today because of the 2018 Farm Bill, which I'm assuming you are all familiar with, but just to remind you all, it had a very broad definition legalizing hemp, including all derivatives, extracts, cannabinoids, isomers, acids, salts of isomers, and it defined that definition in terms of one thing, delta-9 THC, and plants that have a concentration of not more than 0.3% by weight are considered hemp. So that really drew a line in the sand in terms of how we talk about cannabis and cannabinoids in this country and the legal regulatory framework for each of them. With, again, hemp being products that have less than or equal to 0.3% delta-9 THC by weight, and cannabis being everything that's greater than that. What's interesting is they both come from the cannabis sativa L plant, and you can extract many of the same compounds from that plant, whether we call it hemp or cannabis, but the regulatory framework is very different. So I'm going to talk a little bit about what's in place for hemp regulation at the federal level. The USDA was named in the 2018 Farm Bill as the regulator of hemp, but they really regulate agriculture and hemp production. So they are licensing hemp producers. They require record keeping for the land where hemp is produced, They require testing, but only for compliance with that total Delta-9 THC, and they require disposal of non-compliant plants. They are regulating what happens when you grow hemp. They are not regulating what happens to that product after it leaves the borders of the farm. So they do not regulate processing, manufacturing, retail of finished products, or anything that happens to those cannabinoids, again, after they leave the farm. The 2018 Farm Bill actually did not name a regulator for finished consumable cannabinoid hemp products. There are many hypotheses about why that is, including the fact that many in Congress thought that they were voting on an industrial hemp act. And in fact, what's come from that act has been a lot of these consumable cannabinoid products that do not have a federal regulator. The act did note that nothing in the subtitle should affect or modify the Federal Food, Drug, and Cosmetics Act or the authority of the Commissioner of the FDA or Secretary of HHS, but it did not clearly name a regulator for these hemp-derived cannabinoid products. So we have seen FDA action be very limited in this space. It has been limited to some warning letters, really egregious violations and medical claims. We have seen some data collection efforts, some public health notes and sort of health risk notifications to the public, but not much else. So this issue has really been left to states to handle to protect consumers in their own state. And because of the broad definition of hemp, we are seeing a wide variety of products on the market, many of which extend way beyond what would be legal in any state-regulated medical or adult use marketplace, both in terms of the marketing, which you can see here, and in terms of some of the product forms. So we also see very medicalized forms that in any other product category would require high levels of regulation to ensure safety. Things like nasal sprays and lubricants and transdermal patches. We also see highly concentrated products, including instructions for the consumers about how to use those highly concentrated products. So again, extending beyond what any state market would permit. These products are existing in three main regulatory gaps in the Farm Bill. There's something that I would refer to as the derivatives gap, because that definition in the Farm Bill was so broad and legalized any derivative. What we are seeing is the chemical derivation of cannabinoids, some found in the plant in much smaller proportions, some not found in the plant or in nature at all. The process by which these products are being manufactured is manufacturers are taking hemp, they're extracting usually CBD extract from that, and then they're using basic chemistry, acids, heats, and solvents to make an alphabet soup of other cannabinoids. Again, some found in nature, some not, but most of which for which we have almost no safety profile in human consumption. You can also imagine the kinds of acids and solvents being used in the manufacturing can vary greatly, with companies that are more responsible choosing probably better selections for those than entities that are not. This is a fairly easy process to conduct. You can purchase online for, a couple $1,000s the chemistry equipment that you would need to manufacture this. So it's not a sophisticated process, but it's one that states that regulate cannabis are very familiar with regulating to ensure consumer safety, to ensure that solvents are completely removed from the products and that the finished products are safe. But that is not happening in the hemp landscape unless a state has acted to make it. And we continue to see an increasing array of these cannabinoids that are on the market, including some that literally have not been heard of before, that claim to be very potent. Another gap that's existing in the Farm Bill is the THCA gap. So the hemp and cannabis plant actually does not make a lot of Delta-9 when it's growing as a crop in the field. What it makes is THCA, the acid form of Delta-9. THCA in and of itself is not psychoactive or psychotropic, I should say, but as soon as you apply any sort of heat or smoke or combust that product, it turns into Delta-9 THC. It's exactly the reason why your medical statutes in the state define THC in terms of both Delta-9 and the acid form, but the Farm Bill does not do that. So we are seeing, especially online, a proliferation of these THCA products that have very high levels of THCA that when combusted will have that level of Delta-9 THC. Some of them are more surreptitious than others. Some of them are very boldly marketing this, as you can see with this 1 gram THCA diamond. Their website actually says these dazzling diamonds are made from pure hemp-derived THCA, giving you the royal treatment, Your Highness. But don't be fooled by their non-psychoactive facade. These diamonds pack a punch. Heat them up and watch them transform into psychoactive THC, the king of cannabinoids, federally legal and fit for royalty. So that's another regulatory gap that we're seeing. And then the last one is based on the 0.3% threshold. So the Farm Bill defined everything in terms of agricultural weights in the plant. And 0.3% Delta-9 THC in the plant is not a lot of Delta-9 THC. But as soon as you take that 0.3% by weight of a heavier item, like a chocolate bar or a gummy or a brownie, that can be hundreds of milligrams of Delta-9 THC that would be federally legal and Farm Bill compliant. Again, far more than any state market would legalize. So what are the potential health and safety risks? There are a number of them. There are product safety issues, contaminants and byproducts that come from these chemical reactions. And some of these products require many chemical reactions. If even one of those is a dirty reaction, you can end up with a lot of stuff that could be very dangerous for consumers. And then there's no oversight over contaminants, metals, mycotoxins, bacteria, molds, yeasts, et cetera. Consumer safety is a huge issue in terms of packaging, labeling, warnings. I'm going to talk a bit more about that. And then youth access with no federal requirements around age gating. In terms of product safety, as I mentioned, many of these cannabinoid products have no or little data for use in humans. Humans are literally the test case for their safety. There are potential dangerous manufacturing processes involving acids and solvents. There are unknown byproducts. There are a number of studies now showing that these reactions yield a number of compounds that are never identified before, that have never been studied before for human safety, that are in the products. And then no regulation of ingredients or additives, which especially on the heels of the vaping lung injury outbreak, which was not caused by Delta-9 THC, but by vitamin E acetate being added to these products, is certainly an area where consumers should want regulation. In terms of packaging, labeling, and sale, there's not a requirement for any federal labeling on these products to alert consumers to the actual contents of the product or the potential effects. And there is a growing number of media reporting on incidents where somebody did not know that they were purchasing a product that would get them high, that had a public safety incident or effect, and in some cases, an employment effect, because these products can lead to positive drug tests, and there's nothing on the label that requires the companies to note that for individuals. There is no required serving size or package limit, and there's a general lack of awareness among consumers about the effects of these products. You can see some of the incidents here. A bus driver who pulled over with a bus full of people. He was driving cross country on the East Coast, consumed some gummy snacks that he didn't know included THC. Fortunately, he pulled over before he passed out. Another very recent one, a mother who unknowingly purchased what she thought were freeze-dried Skittles for her child, and her child consumed them and ended up in the emergency room, not understanding that it had been a THC product. So a need for much more regulation around consumer awareness and safety of these products. And then finally, youth appeal and access. These products mimic commercial food items. Almost none of what you see on this page would be legal in a state regulated market. They would not meet the compliance for products that do not appeal to kids. In some cases, these products are being sold on the same shelving space as non-THC products. So you can see M&Ms here along with a number of THC infused products. There's also really no requirement for age gating in the online space. So this is an example where all I had to do was check that I was over 21, and I could put 1 gram of concentrates, 250 milligrams of edibles, 500 milligrams of edibles in my cart. And if I had a credit card, I could check out and have that shipped to me. Poison center call data has been increasing. This is brand new from a court brief filed in a lawsuit against the state of Virginia. Just noting that their poison center saw a 2,300% increase in THC-related calls between 2018 and 2022. There's no causal linkage, but that time frame does directly correspond to the time frame that we've seen this market increase. They also note that for children, these products can have very severe consequences. These are not Delta 9 in many cases. They're cannabinoids for which we don't have a good safety profile. So they actually have noted a tragic death of a child where toxicology results showed the child's death was directly caused by Delta 8 toxicity. So lots of reasons to want to regulate this, the last of which is market considerations. In states that are trying to stand up adult use markets, these unregulated markets are a direct competition to that. There are similar products that appear on both markets, but there are much higher barriers to entry in the regulated cannabis marketplace because of regulations that are meant to protect consumer health and safety. Testing requirements, packaging and labeling requirements, this public health focus. Hemp products are not playing by the same rules and have access to interstate commerce and an online marketplace as well. So it's a direct competition to the regulated market. So your state will need to decide, which marketplace makes more sense to your state, a regulated market that has some higher barriers to entry or an unregulated market. There are challenges in the regulation of cannabinoid hemp that other state legislatures have faced. First, that there's no federal regulation or science really to guide you. This is a highly technical subject that can be very difficult for non-scientists. There's a lot of disagreement on terminology, how to define things like impairing, intoxicating, synthetic, what to do about these non-natural synthetics that are not found in nature. Should those be legal and regulated? Should they not be? What to do about full spectrum products that are extracting the compendium of cannabinoids from the plant into a product that may have high levels of CBD, but with that may also have THC, in some cases in proportions that could make somebody high. And then what to do about biosynthetically derived cannabinoids that are coming from yeast and algae. Another challenge is that there are often different state agencies regulating hemp and cannabis. This can leave regulatory gaps. This can present challenges for the industry. Which agency are they supposed to work with on which issue? Where is the line drawn, as well as for consumers? And it can result in literally different regulatory tracks for exactly the same molecule in almost exactly the same product. And then finally, the industry is dynamic and changing. So if your policies are based on regulating what's on the market today, they'll soon be outdated. So examples of state actions that have been taken, and I'm going to give you sort of examples that run the gamut. So the state of Alaska just this past November adopted rules that hemp products with Delta 9 or non-naturally occurring cannabinoids would not be endorsed as industrial hemp, would not fall under their industrial hemp program. Connecticut, through House Bill 6699 and House Bill 6700, defined high THC hemp products as those that have more than 1 milligram total THC, so Delta 8, Delta 9, Delta 10, per serving or 5 milligrams per container. And those products may only be sold by a licensed cannabis retailer in the state and must comply with those regulations. The state of Maryland, their adult use law, the law that legalized adult use in the state, included provisions that products with more than 0.5 milligrams of total THC per serving or 2.5 per package would need to be licensed by the Maryland Cannabis Administration and regulated under that system. Michigan amended a couple years ago their Adult Use Act and statutes to bring regulatory authority over cannabinoid hemp processing, manufacturing, and sale under their cannabis regulatory agency. They did not ban cannabinoids, but they set manufacturing and safety thresholds for things like synthetic Delta 8. And to this day, they've not approved anyone to manufacture Delta 8 because nobody has been able to meet public health and safety standards that other cannabis-derived cannabinoids are subjected to. The state of New York, their Office of Cannabis Management regulates hemp used or marketed for cannabinoid content, including products intended for human consumption. They are licensing cannabinoid hemp processing, manufacturing, and retailing. And then the state of Virginia, SB 903, hemp products must have less than 2 milligrams of total THC per package or more than a 25-to-1 CBD to THC ratio. And that only pertains to in-state sale. There was a lawsuit brought arguing that the law restricted interstate commerce of hemp, and the preliminary injunction was denied to the industry. So there's an increasing trend where state legislatures are giving authority for these consumable cannabinoid products to the same agency that regulates medical or adult use cannabis. And the reason is they know those products, they know those systems. So what we increasingly see is departments of agriculture are regulating hemp cultivation and crops and all industrial hemp uses. Feed, fiber, seed, et cetera. And the cannabis regulatory agencies are increasingly regulating cannabinoid hemp processing and manufacturing, and in some cases sale, where they have the potential to have impact on some of the out-of-state products that may be coming in. They're also regulating for safety and oversight of products that are being consumed. Now, I want to point out that having these regulated by the same agency as cannabis does not mean the same approach or pathway is taken. It merely means you have the same agency that has a line of sight on all of the cannabinoid products. So some advantages that I see to that approach, to having all consumable cannabinoid products under the same regulatory agency, it can provide regulatory consistency across products that are virtually the same, regardless of whether they come from hemp or cannabis. So instead of saying this particular Delta 9, Delta 8 product came from hemp, so it plays by these rules, but this one came from marijuana, so it plays by these rules, you can have some synergy. It also ensures clear oversight over consumable products in terms of both consumer safety and youth access. It avoids regulatory gaps that can come from having multiple agencies involved, where it's easier for things to fall through the cracks and have one agency say, well, that's not us, and another agency say, well, that's not us either, and have the industry and consumers not understand who to go to. It clarifies a point of contact for stakeholders, and it allows the regulatory agency to work with stakeholders to assess the overall risk of products to determine their safety and the appropriate oversight needed and the appropriate endpoint for sale. So to give you some examples of states that have authority over all cannabinoid production, processing, and sale, New York, Rhode Island, and Michigan are 3 states that come to mind. California and Colorado have regulation of cannabinoid hemp with their public health agency, not with their marijuana regulator, but the public health agency works hand in glove with their marijuana regulator. And then there are a number of states that now have authority over all intoxicating cannabinoid products that's been designated to the Cannabis Regulatory Agency. Maryland, Oregon, Connecticut, and Washington are some examples of those states. So what's at risk from regulatory inaction? An increasing number of public health and safety incidents in the state, increased consumer confusion about what is legal, tested, or safe, a potential for further blurred lines between the existing illicit market and the legal market, and really a parallel but unregulated market that will directly challenge any state marketplace that you stand up. We have a number of resources that I've had entered into the record on this, including letters to Congress, fact sheets. We've testified in Congress on this issue. We also had a response to Congress that includes a visual appendix with products that I had entered into the record. So thank you. Appreciate you giving me some time to share insight, and happy to be a resource to any of your offices as you pursue this in your state.
Dr. Schauer, thank you very much for your very thorough presentation. At this point, I'm going to take a second and do some notations. Do not mind my co-chairs needed to step out to vote in a different proceeding. They will return shortly. And for viewers online, this presentation and briefing is again featured and will be archived on YouTube on the Hawaii State Senate YouTube page. Links to this briefing and the presentation materials will be available on the Commerce and Consumer Protection Committee page on the Hawaii State Legislature's website. The YouTube video itself will be bookmarked by presentation because this is a 90-minute briefing, so you can scroll right to this presentation. And the slide materials for these presentations will be available on our legislative webpage and in the links in the About portion of the YouTube video. So everything, and will also be provided to the members. So all of the presentations and presentation materials will be made available online thereafter. Question? Senator Richards.
Yeah, thank you. Really appreciate the in-depth presentation. Just for some clarification, you explained who you are not funded by. Who are you funded by?
We're primarily funded by our member agencies who are all government agencies. We've had occasional grants that are related to NIH grant funding for research or through public health or safety groups like the National Safety Council to help with policy data, but that has been a very small proportion of our funding. We're overwhelmingly funded by the government agencies that are in our membership that pay annual membership dues to us as an association of government agencies.
Okay, and just to follow up, the concern is the unregulated, thereby or lack of oversight of the products that are out there for public safety, and I completely understand that and agree with that concern. Our problem that we are struggling with here is that bona fide hemp growers that want to do it right are concerned they're going to get caught up in the overregulation. What's your response to that?
Yeah, and I work regularly with industry trade associations at the national level, and I want to be clear that there are many responsible actors in the cannabinoid hemp landscape. There are many organizations, entities that are operating as though regulation will come to them and playing by the rules. But the reason for regulation is all it takes is one bad actor, and you have a major public health issue, and nobody will know exactly where that came from. So my response would be that regulation will protect everybody that's involved. I think there's often confusion about what we're talking about. We're talking about regulating consumable cannabinoids, which is very different from industrial hemp. Industrial hemp, as I highlighted, typically still stays with departments of agriculture. And honestly, I don't know a state in the United States that doesn't want to see industrial hemp grow and take off and flourish. And I think the sooner there's a bifurcation of those two, the more likely it will be that industrial hemp farmers will actually be able to be successful because they will have a set of rules that pertains to them as industrial operators, as opposed to folks that are making, cannabinoid consumable products that can be intoxicating and need a different level of regulation. So I think that's what I'm trying to highlight, is that there's a way that states have figured out how to do this sort of differentiation across the landscape of hemp. And what we're really focused on is the cannabinoid hemp. I also want to underscore that just because regulation exists within the same agency doesn't mean all products are treated the same. And there are lots of examples of this. FDA regulates products that can be present in foods and dietary supplements and also present in drugs, and they don't have the same regulatory pathway for all of those. There are guidelines to sort of direct what can reach the consumer safely, and I think that's the opportunity that regulatory agencies in states have, to take this and look at all of it and do a risk assessment and determine what belongs in which pathway and why.
And, some of your comments about some of the other stuff in the theoretically purified products, some of the organic solvents that are used to get these things out. You're the first one to mention that, and that's been something on my mind, so I do appreciate it, and I do understand your concern on that. Thanks, Chair.
Thank you very much, and thank you very much again, Dr. Schauer. If you can just hang with us for the conclusion of the Attorney General's office presentation, we may have other questions at the end. Thank you again. And we'll now have two members of the Hawaii Attorney General's office present next. Thank you very much for joining us, and good morning.
Good morning. Special Assistant to the Attorney General, Dave Day. With me here is Deputy Attorney General Andrew Goff. The Attorney General's office obviously has been involved in this issue this year. SB 335 is a bill that's
3335
is a bill that is substantially based on the work of our department as part of our mission to work with the legislature to come up with a bill that would legalize adult use cannabis and also address many of the concerns that have arisen in other states concerning public safety and public health issues. There is a hemp component to the bill, and we've also been in discussions with people in the hemp industry, and we understand their concerns. And one of the things that we want to speak about now is the current legislative landscape regarding hemp, and also then comparing that with SB 3335. With me, again, is Deputy Attorney General Goff. He is a co-author of a chapter in one of the leading cannabis law textbooks on the chapter on hemp. cannabinoids. So Mr. Goff is going to take it over. I think I just coined a nickname for you.
Good morning, senators and chairs. I'm going to try to keep this as brief as possible, but I said that about the bill too, and it ended up being over 300 pages, so we'll see how this works. So a little bit of background on hemp before we get into the actual nitty-gritty of the state laws as they exist now. Hemp and marijuana are actually the same plant. A lot of people consider them different plants or different varieties. They think if you plant one hemp variety, it will grow into hemp, and that is just not the case. The legal definition of hemp focuses on the chemical composition of the plant and the products, specifically delta-9 THC. That is the compound that will get you intoxicated. Federal law requires that a plant or a product have 0.3% or less of delta-9 THC, and that includes plants, the buds from the plants, industrial hemp products, and cannabinoid hemp products, which we just heard Dr. Schauer discuss. So the 2018 Farm Bill amended the Federal Controlled Substances Act to allow hemp and hemp-derived products. It does require hemp cultivation in a state to be regulated by either an approved state program or by the USDA. Senator San Bonaventura, I think you had a question on this.
Yes.
We will cover it.
Thank you.
And it does allow products to be regulated by the FDA and also states. Now, the initial, as Dr. Schauer had gone over, the initial plan for hemp was for industrial products. Hempcrete, textile, even foods like hemp seeds, you'll find those in Costco, everything like that. What they found when they enacted the 2018 Farm Bill was that there was a large market for hemp-derived cannabinoids. Now, these are cannabinoids that are not delta-9 THC, that are extracted from a hemp plant. But as Dr. Schauer pointed out, these cannabinoids are exactly the same as other cannabinoids that can be extracted from marijuana. And one of the side effects of this was there was a glut in the CBD market, and they discovered that you could turn CBD into other smaller, lesser known cannabinoids like delta-8. And these intoxicating cannabinoids are extremely problematic, and they are everywhere. I do want to point out that a couple of these products are from local hemp businesses. We don't know where the hemp came from, but I have seen these in farmers markets, and if you see the one on the right, it's marketed as vitamin D8. And when I discussed it with the person at the farmers market, they told me it was a sleep aid. They did not mention that it was intoxicating, and there was no mention of age gating or any information about where the hemp came from, how it was derived, or what delta-8 actually is. I'm not going to spend too much time on the trends here, as Dr. Schauer went over that pretty in-depthly, but I will hit the general approaches that states are taking now are to restrict THC content by weight. This would look like on a package for a hemp product cannot have more than 5 milligrams THC per the package or per serving. They restrict artificial or semi-synthetic cannabinoids. Now, this is a way of trying to get at delta-8. If it's changed from CBD into delta-8, as Dr. Schauer mentioned, there are a lot of unintended consequences that we just don't know the health effects of this kind of procedure. So a lot of state laws are looking at cracking down on semi-synthetics. They also prohibit the sale of intoxicating cannabinoid products to minors, basically an age gating process similar to tobacco or alcohol, where somebody has to be over 18 or 21 to purchase what would be federally legal, but also still intoxicating. They also restrict the forms of products. For example, some states prohibit smokable hemp, some states prohibit hemp vapes. We currently do prohibit hemp vapes. In doing all this research, we did discuss with Oregon their approach that they take. And one of the concerns that was brought up by the Hawaii Hemp Farmers Association was that lumping hemp and cannabis together in one agency will cause unintended consequences. And we spoke to Stephen Crowley, who is the cannabinoid hemp, director of the Oregon Liquor and Cannabis Commission. We did include in the materials a video Q&A with him. He was unable to be here today, but it is very informative. If you have an extra 10 or 12 minutes to spare, you should check it out. And he goes into detail about the Oregon regulatory scheme and the difficulties that they've had with hemp cannabinoid products. Essentially, the short version is the Oregon Liquor and Cannabis Control Commission regulates cannabinoid hemp products. They don't regulate industrial hemp products. They don't regulate the growth or the processing or manufacturing of products. That's all Oregon Department of Ag. If it is a cannabinoid product, it's got to go through the Liquor Commission. There is a general market for non-intoxicating cannabinoid hemp products such as CBD, topicals, that kind of thing. They don't really strictly regulate those. For intoxicating cannabinoids, there are age restrictions. Again, if it's federally legal but still intoxicating, you can only be sold for people that are over 18. And there are limits on total THC concentration and synthetic, or what they call semi-synthetic cannabinoids. He did also note that in 2021, there was a program that they had to institute through the legislature that increased inspections for hemp farms because Southern Oregon was being overrun by hemp farmers that were actually growing marijuana. In 2021, they did a bunch of inspections on hemp farms, and they found that over 50% of those hemp farms, at least one test that they did came back and showed that a hemp plant had over 5% THC, which is well above what was allowed. Now there's continuing inspections going on in Oregon. They have since had a decrease in hemp farmers that are applying to their Department of Ag. They think it might be partially because of the national decline in hemp farming and partially because of the increased inspections. But they have seen an increase in industrial hemp farming, so he considered that a good thing. We do include in the presentation, there's a link to the report, I think it was called Operation Table Rock, that outlines this investigation procedure, and he does discuss it in the video as well. Other states, as Dr. Schauer has pointed out, have looked into cannabinoid regulations. I do include a couple links to several task forces that were done by other states if any of the senators want to do some more in-depth research. I would note that the task force in Virginia, one of the recommendations that were made was to create a coordinated regulatory agency and basically consolidate enforcement, such as we're advocating for here. So current Hawaii hemp regulations. The current law in Hawaii is fragmented between several different agencies. Hemp cultivation is regulated by the USDA. So the state does not deal with cultivation at all. You get a federal USDA license. You follow federal USDA regulations for testing and growing hemp. This ends at harvest. The USDA does not touch it after harvest. So you can store it on your farm, and the USDA has no regulatory authority over that. Post-harvest is where the state regulations kick in. And I do note in these slides where Act 263 has made changes this past year. And here, Act 263 added a provision to state law that restricts state regulations from basically requiring duplicative inspections and testing to the USDA. So we can't require, if you're growing hemp, we can't require inspections or testing. That's all USDA. The state regulations do pick up. We regulate buffer zones where hemp can be grown. Department of Agriculture currently regulates that. That's in 141-42. And basically you can't grow hemp within so many feet of a playground, a school, or a current residence. There was an issue where a hemp grow was right next to a residential neighborhood and they were overwhelmed by smell, so these buffer zones were put in to kind of allay that concern. Act 263 shrunk those buffer zones from 500 feet for a playground or school to 300 feet, and for a residence, 500 feet to 100 feet. Hemp transportation, currently if you harvest hemp, once it's harvested, you can't transport it off of your farm unless you submit a movement report. You have to submit a movement report to Department of Agriculture, and the only place that you can transport it is to another USDA licensed farm or to a DOH permitted processing facility. All hemp has to be reported to DOA. I talked to DOA the other day, and they said last year they received one movement report. So I don't know if there's no movement going on or if that's just not being done. I do note too that Act 263, one of the amendments they made was they were removed the DOA's authority to administratively inspect or test hemp being transported. And so now we have no way to determine whether the hemp is actually hemp or is illicit marijuana. Hemp processing is currently regulated by Department of Health. This is just for cannabinoid products. Does not touch industrial hemp. All processors have to have a DOH permit. This includes USDA licensed hemp farmers, and processors have to follow good manufacturing processes. Those are outlined in rules. Act 263 allows for crude hemp extract, which is an addition to the law that's being implemented by rules right now. Basically, you can process this crude extract with less stringent testing, and you can sell it to other processors for finishing. It also allows certain kinds of hemp processing in an agricultural building as defined by HRS 46-88. That was a direct request from the Hawaii Hemp Farmers Association, I believe. The products themselves are all regulated by Department of Health. Also, all cannabinoid products have to comply with testing and labeling and product requirements. DOH currently has the authority to limit cannabinoid content of a product by rule. All hemp vapes and smokable hemp products are currently prohibited as a form. And again, industrial hemp is not regulated. And again, crude extract is now allowed to be sold just to processors, not to another consumer. Now, the regulator is currently the Office of Medical Cannabis Control and Regulation, and that's because we're dealing with cannabinoids here, and really the experts in cannabinoids are the Office of Medical Control, Cannabis Control. This ensures that there is some synergy between hemp cannabinoid product regulation and other cannabinoid product regulation, and so you're not allowing one in one area and not allowing one in another area. Hemp regulation, as Michelle pointed out, is currently funded only by permit fees. There is no funding allocated for Department of Health, and the personnel has to be used for enforcement is the OMCCR staffing. Enforcement is a little difficult. Multiple jurisdictions have authority, so that creates gaps and leads to confusion over which department needs to be involved, which department needs to be the lead. There's questions over whether a product is criminally illegal. Hemp is one of the strangest legal things to work with, because if you do it correctly, it's legal. If you do it incorrectly, it is criminally illegal. So Department of Health isn't really used to regulating like that. And you have to call in law enforcement, but then law enforcement isn't used to the administrative side. So that creates a little bit of a rift that makes it difficult to really enforce. And as I note, the enforcement is fragmented across several agencies: DOA, OMCCR, the Office of Consumer Protection, and my office. And a lot of times there's a lot of, no one knows who is taking the lead, no one knows whose authority is what to work with. So to go over SB 3335 relating to cannabis and how my office has incorporated hemp into the cannabis authority. As we note here, all of the fragmented agencies get consolidated under the Hawaii Cannabis Authority. The USDA will still have sole regulation over all growing aspects. After harvest, the HCA takes over, and there's no, does DOA regulate this? Does health regulate this? This is a consumer protection action. HCA has all of the authorities to do any enforcement. Yeah, we actually also eliminated, if you'll see, the DOA has hemp transportation currently. We eliminated the movement report requirement, and so that does free up some hemp producers. At any point in time, every point in time, we tried to eliminate things that weren't working or free up some of the hemp regulations. So putting everything under one agency creates consistent and uniform regulations, and this actually provides certainty for ancillary businesses such as banks and insurance companies. And we did hear from the hemp farmers, one of their concerns for consolidating under one agency is that they'll be lumped in with cannabis, and banks will say, I don't want to deal with cannabis. And that is not our experience. We just did discuss this with the Oregon regulator. He said that wasn't his experience either. This is in the video as well. He routinely works with banks. They ask for compliance checks. They ask if the hemp producer is licensed. And in our experience, banks don't like uncertainty. They don't like questioning whether this business is criminally illegal, whether there's an issue with the business itself. Now, providing clear regulations and having one enforcement agency to discuss this with provides certainty for banks so that they can know, I just have to check with one person, I don't have to check with 4 different agencies to see if this business is legitimate or not. It also ensures that one agency is the subject matter expert regarding cannabinoids. This is extremely important. This is a really complicated area of law. And if you have, you basically have to create little cannabinoid agencies in all of these separate agencies. In DOA, in DOH, you'll have to have a new one in HCA. And there's really no need to have all of those when you can have it consolidated into one. So that eliminates a lot of duplicative state departments. And it also ensures that one agency has enforcement authority and the funding to go and do this. So consistent enforcement from a single agency funded by adult use cannabis sales tax. I think that's the one piece that's missing from enforcement currently. Hemp, you have to cast a wide net. There's no retail license that's necessary. You have to go to every gas station. You have to go to every shop in Waikiki, in the mall. We currently have, I think, 8 cannabis investigators to effectively regulate this and enforce these regulations. We're going to need more personnel to go and do this. And funding using adult cannabis sales tax just makes sense for that.
If I may, Andrew, thank you. We need to wrap up at 11. There's about 15 minutes left. I would like to reserve a few minutes of time for Q&A.
Yep.
So if you could proceed with the rest of your presentation expeditiously, please.
Of course. I did want to note also industrial hemp is not regulated as a cannabinoid product again. We did want to note too that the intent here was to not increase the regulatory burden. The idea is to completely take the current rules and put them just directly under the HCA. So the rules will not change. The current hemp processing permits will transfer to the HCA. Local compliant products, including all the CBD topicals, balms, and salves, will not require a license or permit to sell, and the fees don't change from the existing rules. It does provide clear authority to restrict certain cannabinoid products. There's a mechanism to basically say that certain products are restricted and need to have a permit to sell, and those would, like Delta 8 vapes and gummies, can be completely prohibited as well. And it provides clear authority to inspect and enforce against the products. Once again, I want to note that industrial hemp is not included in this cannabinoid hemp. So all of the processes with textiles, hempcrete, grain, fiber, those aren't going to be regulated by the HCA. And finally, we did include in Act 263, or we included in SB 3335, several provisions from Act 263. Those include a provision restricting state regulations from requiring duplicative sampling from the USDA regulations, included the buffer zones that were in there, provisions allowing for crude extract, and provisions allowing for processing in ag building. And again, industrial hemp is not included. And that's everything. I know that's a lot, but
All right, thank you very much. To the members who joined us during that presentation, it was immediately preceded by Dr. Schauer, who was online and presented on behalf of the National Cannabis Regulators Association. And again, before them was the Department of Health Office of Medical Cannabis Control and Regulation. We have about 13 minutes left, so I'd like to open it up to questions from the members. We'll go to Senator Richards.
Okay, actually, go ahead, Senator Gabbard first.
Okay, regarding the, I don't know if you've heard about a farmer in Oregon, Ken Iverson of Iverson Farms. He's one of the largest hemp farmers in Oregon, and he's been told that he will, by his bank and insurance company, that he will lose both services if he grows hemp this year, which he had planned on doing, and that's not any kind of intoxicating product. So are you aware of Ken Iverson's situation?
no, that wasn't brought up when we discussed that in Oregon, but he's a hemp farmer or he's a cannabis farmer?
Hemp farmer, yeah. He's one of Oregon's largest hemp farmers, yeah. So, and in relation to that, as you know, talking to the Hawaii Hemp Farmers Association, that's one of their major concerns. In fact, the head of it lost their insurance from Lloyd's of London in 2021, and they were told because it was the fact that they were growing hemp. And so is there any way that we can, in the bills that, what are they, 23?
3335 is the
600.
Senate bill, and then 3133 is the
We
other
can
side.
guarantee that our Hawaii hemp farmers and business will not lose their banking and insurance and other hemp business services as a result of.
Yeah, I mean, guarantee, I don't think, but we do include for cannabis farmers a provision that allows us to share information directly with banks, and we could include that with hemp as well. So again, in my experience, and we did discuss this with Oregon, and he did not bring up Ken Iverson as an issue. In my experience, the banks are a little wary of hemp in general because of the shifting regulation and because of the potential to go into an illegal substance. So, I mean, to the extent we can include hemp information sharing, and then the bank can use our information, our inspections, and our product information to do their own due diligence, I think that would go a long way to help the banks.
And then just to note as well, we did invite the Oregon Liquor and Cannabis Regulating Authority to participate, and they were unable to participate live in the briefing.
Right.
We are including a video of a Q&A that took place to try to address some of the issues that we were hoping that they would present on in this briefing. And we can also try and work to get questions directly to them and see if they might be able to respond.
And maybe, Chair, we could get a opinion from the insurance commissioner about Lloyd's of London in general, getting out of the specialty insurance business. I mean, because they're also doing it for lava zones too. So they're contracting because they are mostly a reinsurer firm instead of a specialty insurance firm.
So we will note that and include that as a follow-up question to the Insurance Commission.
Yeah, thank you. And just a little bit follow-up after Senator Gabbard. The banking and insurance is a big issue, and I know that. And so I'm not sure if the statements you made are completely accurate. That being said, they may be able to obtain the insurances, but they may be vastly more expensive, and that's also a concern going forward. So I think we have to drill down on that a little bit more. I'm assuming, actually, I want you to answer the question. The reason for this regulation is what?
To include hemp within.
Correct.
So I think the philosophical reason and the legal justification was to create a framework that would allow for one entity to regulate intoxicating hemp products along with adult use cannabis if the decision is made by the legislature to go down this path. Dr. Schauer, spoke at length about sort of the reasons why there's a benefit for doing that, and we agree with those reasons. We have looked into, and we spoke with Oregon about some of the concerns that were raised by the Hemp Farmers Association here, specifically with respect to banking. I'll just note with banking for instance. In the gentleman's experience, Steve Crowley's experience, one of the things that he felt was that the banks appreciated that the information could be given that this is an entity that had a license and was operating in good standing. The fact that that entity, the hemp cannabis, the cannabinoid hemp products licenses were regulated by the same entity that regulates cannabis in the state, did not
Okay,
seem to.
hang on. Yeah, I got all that, but why? What's the intent? Public safety is.
Public safety, correct. And
Okay.
public health.
Okay, and public health. Okay, so, again, if farmers are not going for a higher end product, the cost of doing that business. So did I understand correctly? You said that the adult use cannabis would fund the regulatory side for the hemp producers?
That's the plan, yeah. So the whole HCA, the Cannabis Authority, would be funded by the adult use cannabis tax. And there's no extra tax on hemp products, but the entirety of the agency would be funded through tax.
Okay, because I want to visit that a little bit more, probably at a later time. We've agreed, and again, the legislative pinky promise, you guys are ready to meet with the hemp industry, correct?
Including Attorney General Lopez.
Okay, yes, AG will be there. Okay, thank you, Chair.
Okay, I have a bunch of questions.
Senator San Buenaventura.
Okay, thank you very much. So right now, when I asked the questions of Department of Health, basically their solution to illegal products is to just embargo or confiscate. When you talked about these intoxicating cannabinoids like the Delta 8, and I remember Director Anderson saying CBD is supposed to also be considered illegal. But I don't see you guys embargoing or confiscating those. I mean, is that the extent of your enforcement now? And if it goes towards the SB, if we pass SB 335, and are you expecting more enforcement authority to ensure that the Delta 8s, the illegal CBDs will be not only confiscated, but hopefully fine the sellers?
Yeah, so we did include actually a provision that makes it, I believe, a crime to sell what we would consider restricted cannabinoid without a permit. And then there are provisions to allow for fines and cease and desist orders.
So it's just a question of enforcement since it's, okay.
And Senator, if I may add, one of the aspects of the bill that I think would really increase the enforcement on these imported products and these illegal products that we're seeing in stores is the proposed creation or expansion of a cannabis nuisance abatement unit, which is intended to civilly address basically allowing things to be taken off the shelves. And that would be something that would be dedicated to cannabis and hemp products and would be something that would be effective statewide. We intend for that to be kind of a pretty robust unit. This was something that was suggested by Representative Tarnas during the drafting process.
Okay.
In addition, there's a proposed 17-member unit that would be within the Department of Law Enforcement that would be able to address the criminal aspects of, for instance, the sale of illegal products or the sale of some of these products to children. And things like that.
Okay, so because according to somewhere, one of your slides, the Department of Health regulates sales, right?
They regulate the products.
Post-harvest,
Yes.
right? So right now, if to me, it seems like it's gonna be a pro-local farmer issue if we are able to enforce the illegal products, because our local farmers are gonna be tested and they know what's legal. So, I mean, so I'm for you folks actually enforcing the law, okay? So that these illegal products come in. One other thing, post-harvest, is it gonna be Department of Health or is it gonna be, well, I guess Department of Health is gonna be part of HC's, the new cannabinoid authority that will determine, that will regulate post-harvest sales and licensing?
Yeah, that would be the Cannabis Authority. So,
Because right now, you had said that you're not gonna require a movement report. So that's one of the, I think, concerns is, let's face it, actual cannabis has like seed to sale, highly regulated, but you're actually saying that if we pass this bill, you're actually making it a bit more lax by not even having the hemp version of seed to sale, which is the movement report.
that's right, we don't require any tracking of the hemp, but we would, basically, it amps up the inspection authority.
So
So you would
what-
have the authority to go in and inspect, you would have the money to equip law enforcement and inspectors with, they have like hemp test kits that you can just get a read on it real quick and see if it's hemp or if it's marijuana.
So if it's determined to be marijuana, which is an over 5% Delta 9 THC, what happens to the hemp product?
It would need to
Be destroyed? And not, if we pass this bill, are you gonna allow for any kind of remediation?
That would be up to rules, really.
Rules, okay?
We did a lot of, my plan was to put everything into like rules and not have the statute read too restrictive. But we did also include some things that were important to put in there, and also at the farmer's request, a lot of things from 263 that they wanted.
Okay, basically that's it.
Members, any other questions? Okay, I have one question, and I think we're gonna run a little bit over time. So industrial hemp's not regulated, the USDA is dealing with growth of hemp. By my read of the way the licensing framework works for cannabis, cannabis cultivators need to apply for a license. So, if there are, I guess this bill does contemplate growers of hemp who may also apply and receive a cannabis manufacturing license. Okay, so if you can't inspect the hemp in the ground, but you can inspect the cannabis that's licensed to be cultivated, if there's a grower who is growing hemp and licensed cannabis, how is an inspector going to be able to tell which is which on the farm?
Yeah, that's a great question.
Because you can't test the hemp, but you have to test
Yeah.
and inspect the cannabis. If I'm a hemp and cannabis manufacturer,
Just put them together.
how do I just, why don't I just go, oh, that's all hemp?
Yeah, we did include in the buffer zones, we added a requirement that you can't grow hemp and cannabis together. So the fields would have to be different. And also, I don't know if this will get fixed or not, but my understanding is currently the USDA does not allow a hemp grower to also grow cannabis. So if you have a license to grow cannabis from a state, the USDA will not license you. That might change in the future, but that's my understanding of the current situation.
If the vehicles continue to move, some clarity on that might be helpful as we go along, because my concern is whether the substantively in the measure, if it proceeds, whether there are brighter lines that can be drawn within the cannabis authority so that when the hemp community is dealing with regulators, they know they're not dealing with the cannabis guys. They're only dealing with, in the same way that it has been presented by multiple presenters that having expertise in cannabinoids is very important, consolidated within one regulator. It is also important, I think, and fair to the industry to know that they are dealing with hemp experts if they're growing hemp. In the same way that cannabis experts are hoping they're dealing with cannabis experts and not hempcrete regulators, because that can get probably very annoying if you're a business person trying to turn a profit and then follow the rules.
Could I just address one thing?
Yes.
So, Michelle was speaking about the fact that in 2025, she's going to be, or fiscal year 2025, she'll be getting funding for 4 positions specifically for hemp. And that would be, I believe, a separate division within that. I think that something like that, granted, this is something kind of looking into the future about the way that the authority would be organized, but I would assume, and I think would be appropriate for there to be a division that would be specifically related to that.
Michelle, can you address that now briefly? Because even if the bill does not proceed, your office is still basically in charge of these regulations. I know it's been said 30 times in this presentation that industrial hemp uses are not regulated, but how do I have assurance if I'm growing hemp rope? I don't want to see you, I don't want to know you, I don't want to deal with you. And if I'm following the rules appropriately, I shouldn't have to, right?
Correct. And so the intent is, as David mentioned, we will have 4 positions. I intend to stand up a separate section that's specifically for hemp inspection, regulating, oversight. However, I do still argue that it's beneficial that we're within the same agency, because the subject matter, when it comes to considering what should be the testing standards, right? What should be packaging and labeling requirements, ingredients that are allowed in manufactured processes, those sorts of things. And the components of what should go into the inspection of the production facilities, the retail locations. Those things are all common, and we can serve the benefit. It makes the program a lot more efficient. It makes the process more efficient. There's a lot more certainty for the industry.
Thank you. I think
good.
we've
Enough
covered
for now.
as much as we can here. I'd like to thank you,
Yes.
Dr. Schauer, Michelle in the Department of Health and the Attorney General's office for joining us, and all the members. Again, this YouTube video will be archived on the Hawaii State Senate YouTube page. It will be bookmarked according to presentations, so it's easier to search, and all the materials will be available online. So mahalo again, and with that, we are adjourned.